Is it two or one, ma'am? Oh, two different ones or the same one? Subscriber information?
All rise for the jury.
Good morning, everyone. You may be seated. I apologize for the delay. I had a hearing to take care of. So what's going to happen is I'm going to read you this charge. You're going to get a copy of this charge and take it back there, kind of like last time. And then both sides, I gave them 40 minutes, but they promised they would give some time back. And then you'll have the case to yourselves again. Both sides ready, correct?
Bench is ready, bro.
Thank you. Good morning, by the way. In cause number 1926763, State of Texas vs. Attorney Earls, court charge on punishment. Members of the jury, you have found the defendant Tony Earls guilty of the offense of manslaughter. Now you must determine the punishment to be imposed on the defendant. The parties will soon present final arguments on punishment. Before they do so, I must now give you the instructions you must follow in determining the defendant's punishment. You will have a written copy of these instructions to take with you and to use during your deliberations. I will first tell you about some general principles that apply in all criminal cases, then I will tell you about the specific law applicable to this case. Finally, I will instruct you on the rules that must control your deliberations. General principles. Jury as fact finder. As the jurors, you will review the evidence and determine the facts and what they prove. You judge the believability of the witnesses and what weights to give their testimony. In judging the facts and believability of the witnesses, you must apply the law provided in these instructions. Evidence. In determining the sentence to be imposed on the defendant, you may take into consideration all the evidence admitted before you. This includes the evidence admitted during the first stage of the trial concerning the defendant's guilt, as well as any evidence admitted during the punishment stage. The evidence consists of the testimony and exhibits admitted in the trial. You must consider only evidence to reach your decision. You must not consider or discuss any other thing that is not evidence in the trial. You must not consider or mention any personal knowledge or information you may have about any fact or person connected to this case that is not evidence in the trial. Statements by the lawyers are not evidence. The question asked by the attorneys are not evidence. Nothing I have said or done in this case should be considered by you as my opinion about the facts of the case or influence you to vote one way or the other. You should give terms their common meanings unless you have been told in these instructions that the terms are given special meanings. In that case, of course, you should give those terms the meanings provided in the instructions. While you should consider only the evidence you are permitted to draw reasonable inferences from the testimony and exhibits if those inferences are justified in light of the common experience. In other words, you may make deductions and reach conclusions that reason and common sense lead you to draw from the evidence. You are to render a fair and impartial verdict based on the evidence admitted in the case under the law that is these instructions. Do not allow your verdict to be determined by bias or prejudice. Admitted exhibits. You may, if you wish, examine exhibits. If you wish to examine an exhibit, the foreperson will inform the court and specifically identify the exhibit you wish to examine. Only exhibits that were admitted into evidence may be given to you for examination. Testimony. Certain testimony will be read back to you by the court reporter if you request. To request that testimony to read back to you, you must follow these rules. The foreperson must make the request in writing and sign it. The request, number one, must state that it's requesting that testimony to be read back. Number two, state that you have a disagreement about a specific statement of a witness or a particular point in dispute. Number three, identify the name of the witness and who made the statement. The court will then have the court reporter read back only that part of the statement that is in dispute. Burden of proof for wrongful acts. During the trial, you heard evidence that the defendant may have committed a wrongful acts and that did not result in any criminal charges or that did not result in criminal convictions. You are not to consider any evidence of any particular wrongful act unless you find beyond reasonable doubt that the defendant did, in fact, commit the wrongful act. Those of you who believe the defendant did the wrongful act may consider it. Assessing punishment. You must arrive at the amount of punishment by a full, fair, and free expression of the opinion of the individual jurors. You must not decide the punishment by law or chance, or by chance. For example, you may not agree beforehand to be bound by the result of a procedure by which each juror gives the number of years the jurors thinks should be served. These are then added and the result is divided by 12. To reach a verdict, all 12 of you must agree. Specific law applicable to this case. Relevant statutes. This offense is punishable by, number 1, any term of imprisonment for no less than 2 years and no more than 20 years, or any term of imprisonment for no less than 2 years and no more than 20 years, and a fine no more than $10,000. Community supervision. The defendant is asked that you recommend to be granted community supervision. You may, in this case, be able to recommend that the confinement assessed by you and any fine assessed by you or both be suspended and the defendant be placed on community supervision. Community supervision is often called probation. The two terms mean the same thing. If the defendant is placed on community supervision, the defendant will not be required during the period of community supervision to serve the period of confinement assessed by you. If you assess a fine and recommend that the fine be suspended, the defendant will not be required during the period of community supervision to pay that fine. If the defendant successfully completes the period of community supervision, the court will discharge the defendant. A defendant so discharged will never have to serve the confinement assessed by you or pay the fine, any fine that you have recommended be suspended. During the period of community supervision, conditions will be imposed on the defendant and the defendant will be placed under a variety of programs. If the defendant is believed to have violated the conditions of community supervision, the defendant will be brought before the court. The court, after a hearing without a jury, will either continue or revoke the community supervision. If the court revokes the community supervision, the court will dispose of the case as if there had been no community supervision. If it will sentence the defendant to a term of confinement not exceeding the term assessed by the jury. It may also require the defendant to pay any fine assessed by the jury that the jury recommended be suspended. The duration of the period of community supervision will be determined by the court. It may not be for a period for no longer than 10 years. If you recommend that the defendant be placed on community supervision, the court must grant the defendant community supervision. In addition, if the defendant is granted community supervision, the court may impose other reasonable conditions that it is designated to protect or restore the community, protect or restore the victim, or punishment, rehabilitative, or restore the defendant. During the period of community supervision, the court may at any time alter or modify the conditions imposed on the defendant. You may recommend that the defendant be placed on community supervision only if both of the two requirements are met. Number 1, the punishment you have assessed is not more than 10 years confinement, and number 2, you find the defendant has never been convicted of a felony in this state or any other state. If you decide to recommend that the defendant be placed on community supervision, you should indicate whether you recommend suspension of the term of confinement, any fine, or both. If you decide not to recommend that the court suspend the sentence and place the defendant on community supervision, you should use the verdict form that does not recommend community supervision. You have found the defendant, Tony Earls, guilty of manslaughter, parole, and good conduct time. The length of time for which a defendant is imprisoned may be reduced by the award of parole. Under the law applicable in this case, if the defendant is sentenced to a term of imprisonment, the defendant will not be eligible for parole until the actual time served equals 1/2 of the sentence imposed, or 30 years, whichever is less. If the defendant is sentenced to a term of less than 4 years, the defendant must serve at least 2 years before the defendant is eligible for parole. Eligibility for parole does not guarantee that parole will be granted. It cannot accurately be predicted how the parole law might be applied to this defendant if sentenced to a term of imprisonment, because the application of that law will depend on decisions made by parole authorities. You may consider the existence of the parole law. You are not to consider the manner in which the parole may be applied to this particular defendant. Rules that control your deliberations. You must follow these rules while you're deliberating and until you reach a verdict. After closing arguments by the attorneys, you'll go into the jury room. The foreperson should conduct the deliberations in an orderly way. Each juror has one vote, including the foreperson. The foreperson must supervise the voting, vote with the other jurors on the verdict, and sign the verdict sheet. While deliberating and until excused by the trial court, all jurors must follow these rules. Number 1, you must not discuss the case with any court officer or attorneys or anyone not on the jury. Number 2, you must not discuss this case unless all of you are present in the jury room. If anyone leaves the room You must stop your discussions about the case until all of y'all are present again. Number 3, you must communicate with the judge only in writing signed by the foreperson and given to the judge through the officer assigned to you. Number 4, you must not consider any independent investigation, research, or experiments. Number 5, you must tell the judge if anyone attempts to contact you about the case before you reach your verdict. After you have arrived at your verdict, you are to use one of the forms attached to these instructions. You should have your foreperson sign his or her name to the particular form that conforms to your verdict, rather. After closing arguments by the attorneys, you will begin your deliberations to decide your verdict, signed by Judge Danilo Lacayo in the 182nd District Court of Harris County, Texas. Punishment verdict form. Verdict. No recommendation of community supervision. We, the jury, having found the defendant Tony Earls guilty of the offense of manslaughter, assesses punishment at, then there's a blank, imprisonment in the Texas Department of Criminal Justice for a term of blank years. The range is 2 to 20 years, and no fine. There's another option, imprisonment in the Texas Department of Criminal Justice for a term of range 2 to 20 years, and there's a spot for a fine. The range is $10,000 or less. There's a signature spot for the foreman to sign and also print. Next option, verdict, recommendation of community supervision. We, the jury, having found the defendant Tony Earls guilty of the offense of manslaughter, assesses punishment at, there's a space for imprisonment in the Texas Department of Criminal Justice for a term. There's a range 2 to 20 years and no fine. Next page rather. Imprisonment in the Texas Department of Criminal Justice for a term. There's a range 2 to 20 years, and there's a fine $10,000 or less. Having assessed punishment at no more than 10 years imprisonment, we further find the defendant has never been convicted of a felony and recommend he be placed on community supervision. We recommend suspension of, and it's a select one, the term of imprisonment only, any fine assessed only, the term of imprisonment and fine assessed. There's a space for the foreman of the jury, and there's a space for the foreman of the jury to print as well. Each side will have 40 minutes. I don't believe they're going to use that time. However, I did grant them that time. State, do you need a warning? What would you like?
I'm okay, Judge. Thank you.
Okay, and defense, did you need a warning and time?
I don't think we'll need one instruction.
Okay. State, do you want to go first or last, or you want to split?
The state will open.
Sir?
The state will open and reserve its right to close.
Okay, I'm going to set my timer, then you can start. Pardon me. When you start speaking, I'll start counting.
Thank you, Your Honor. Good morning. The beauty about our justice system is that we get to have 12 people from our community represent us. 12 people from different parts of Harris County, including Katy, including Cypress, including Pearland, including all of the different parts. And we get the 12 of you that get to make a decision and be the voice for our community. And I know that every one of you has been attentive and watching the evidence and watching the testimony, and you know what the evidence is. As much as they would like to think that we're going to stand up here and I'm going to pull on your heartstrings, all I've ever talked to you about is the law and the facts, because that's what matter, right? And so this is the law. It's the same copy, similar copy of what you guys had in Guilt Innocence. The first 3 pages are the general principles. What you heard as evidence and what you saw as evidence is what's going to guide your deliberations. Okay? Page 3, guys. The first 2 pages are general principles. Page 3 is the punishment range. Page 3 tells you that a manslaughter punishment range is 2 to 20 years, and if the defendant's eligible for probation, you may consider it. But I'm going to take you back to jury selection, okay? When we were talking to you in jury selection about being able to consider the full range of punishment, by design, we wanted, Mr. John and I wanted, the citizens of Harris County to represent this jury. We wanted Harris County's voice to be heard in this courtroom. Hypothetical for you to consider probation. And honestly, only reason I'm talking about it to begin with is because they called the probation officer to the stand. I'll tell you flat out, this is an inappropriate case for probation. A probation case is like the example John gave you in voir dire. Somebody's at a New Year's Eve party. Someone's at a 4th of July party.
I'm gonna object.
They shoot.
Hold it. That's improper argument to tell the jury what would be an appropriate example for probation. They have to determine the facts in this case and what's appropriate.
I'm gonna sustain that objection. Remember what I've told you before with respect to statements given by attorneys. The evidence is here, the law is in the charge, arraignment evidence here that came from the stand.
Judge, I would ask, I'd move for a mistrial at this point.
That'll be denied, sir. You may continue.
A probation case requires somebody to accept responsibility. A probation case requires somebody to say, yes, I did that. A probation case requires somebody who's willing to accept responsibility. They asked the probation officer, well, as part of probation, the judge could sentence him to some jail time, right? Yeah, 180 days for killing a 9-year-old girl. You want to talk about what is egregious? Here are 3 principles I want to guide your deliberations. You ready? Number 1, the facts of this case. And make no mistake, there is nothing more egregious than the defendant sitting on the stand admitting to wanting and having the intent to kill somebody when he got out of that car. Admitting that he had the intent to kill every person in that truck. There's nothing more egregious than that. Second thing, mitigation. Third thing, future danger. The thing about probation is, if you place a defendant on probation, the maximum amount of time that they can get, if the probation is revoked, is 10 years in prison for killing a 9-year-old girl. And that's not even the most egregious thing. Because I asked the probation officer, what is the most insightful thing when it comes to a person's conduct and the future danger that they may present? And that's past behavior. Think about this for a moment. You get to decide what the evidence is. He sat on that witness stand, and we asked him. Because, they kept saying, we want to know the why. Don't you guys want to know the why? Don't you want to know why? Don't you want to know why? We did. So we said, all right, Mr. Earls, while you're on the stand and we're watching State's Exhibit 108, I don't have to play it for you guys. I know you've all watched it. We're watching State's Exhibit number 108. When you got out of that car, you got out angry. You got out wanting to shoot and kill. Nope, I heard gunshots. That's just not true. It's not true. When you saw the Alvarez's vehicle, you started shooting into it before it made a tire screech. He says, no, I shot at it because of the way it's driving. That's just not true. Every one of you is watching the same video. We've been in trial for 8 days. He's been in this courtroom watching it with you and still not willing to accept responsibility. Okay, Mr. Earls, this is the most egregious thing about that aggravated assault family member. 13 months after he takes the life of a 9-year-old girl, he is outside of a convenience store with a gun in his waistband. Some of you may have never touched a gun again after doing something that terrible. That's a reasonable person, probably never touches a gun again. But we have gun laws in Texas. And I think those of you who believe in those gun laws are probably the most offended. Because after killing a 9-year-old girl, he's just reckless. He takes a gun out and he sticks it in his stepson's face. And after he's done sticking it in his stepson's face, he pump fakes him. He punks him. And then we're all sitting here, again, watching the video. All right, Mr. Earls, clearly he doesn't pull out a handgun. You can admit that, right? No, I saw him reaching for a gun. Mr. Earls, I mean, you point the gun in his face. Oh no, I was pointing around him to the end of the shopping strip. There are two Tony Earls. This is future danger. There are two Tony Earls. One of them is the sad, downtrodden Tony Earls that you've seen in this court. The real Tony Earls is the Tony Earls when no one is looking. When he thinks no one is looking. When he thinks that he is not going to be seen. And that's the dangerous thing about probation, is unless he picks up a new case, we'd never know he had a gun again. The Tony Earls that we know is the Tony Earls that's on video. The Tony Earls that's the real Tony Earls is the Tony Earls that's on video. He's the one unloading into the truck. He's the one sticking a gun in his stepson's face. That's Tony Earls. The question is, the only question left, and I'll tell you this before we get to the last question. The fine, it doesn't go to the family. The Alvarezes, they'll never be made whole. They lost Arlene. And his concern was teaching his stepson a lesson with a gun, sticking it in his face. And you heard the probation officer. The best indicator of future behavior is past conduct. If you don't think that this man, even if you give him the 20 years, and yes, we are asking for it, because even if you give him the 20 years, when he gets out, he's gonna get a gun. He's gonna stick it in his waistband,
I'm gonna object.
and then he's gonna be,
Stop. Hold on, I'm gonna object. There's no evidence that he would do that. There's no evidence. It's improper jury argument.
That'll be sustained. Continue.
I'm gonna ask for a mistrial, Your Honor.
That'll be the next, sir. You may continue, Mr.
9 months after killing a 9-year-old girl, he had a gun stuck in his waistband hanging out at a convenience store. He pulled that gun out, he stuck it in his stepson's face, then he got on that stand and he refused to acknowledge everything that you have seen with your own eyes. That's why probation is offensive. The question is, are we going to at least do everything that we can to ensure that our community is safe, to speak for the citizens of Harris County, to tell them and send a message? You don't get to unload into a car intending to kill everybody in the vehicle, kill a 9-year-old girl. 13 months later, stick another gun in somebody's face. We're not going to wait around for any more victims. For the next 20 years, our community is going to be safe. We trust you to send that message, and we trust you to make the right decision. Follow the law. Consider the facts. We know exactly what he's going to do when he gets out of prison.
29 minutes.
Can I proceed, Your Honor?
Give me 1 second. Let me start your time. I apologize.
I'm sorry?
I'm just starting your time. Give me 1
Oh,
second,
you can
sir.
start.
I apologize. Go ahead, sir.
Thank you.
Thank you.
May it please the court,
Yes, sir. Thank you.
ladies and gentlemen of the jury, good morning. It's not an easy job being on that side of the table when you have such an emotional trial. And, you know, make no qualms about it. You've been here now for over a week, about a week, a little over a week with us, and it's an emotional situation, all kinds of emotions. When you have an emotional trial like this, you have sympathy, it's natural. You have anger. You have the feeling of wanting revenge. And those are all human feelings to have, okay? They really are. I mean, let's be realistic. When Wendy Alvarez took the stand, we heard all about Arlene, and make no bones about it. I mean, she was a beautiful little girl, and she made us all chuckle a little, even in such a tragic situation. We heard about things she would say, things she liked to do, and it's natural for you as jurors. It's natural for them, natural for us, natural really for everybody in this courtroom to, for it to pull on your heartstrings, okay? I mean, you wouldn't be human if it didn't, okay? And then the situation, talk about anger for a minute, it's a natural response, certainly for the family to be angry at Tony, and I'm sure some of you are. And then, again, that's a natural feeling. Nobody wouldn't expect you to feel that way. And then there's the desire to maybe seek revenge, okay? That's a natural human response. The old adage, an eye for an eye, okay? But this is really not that kind of situation, because an eye for an eye, there may be circumstances that may make you feel that way, think that way, but this really isn't that kind of case, okay? And I'm not going to tell you what's appropriate or what's not appropriate. An interesting point about your verdict the other day. I've been doing this a long time. It didn't surprise me. But it didn't take you that long collectively to send a message to Tony Earls that what he did was wrong, okay? I mean, honestly, I don't even think we sent the evidence back. So that tells me, as an attorney, that collectively, you were sending a message, okay? And hey, we understand that you were robbed at gunpoint. We understand that you saw the fear in your wife's face, but you shouldn't have shot at the truck. Regardless of what you were thinking, or more importantly in this case, not thinking, because he acted so, maybe it was an adrenaline pump. I think the psychiatrist talked about that, psychologist, maybe you were thinking flight. I wasn't there. You weren't there. We don't really know what was going through Tony's mind. But that being said, the point is that what he did was wrong. You guys know it. And now you have to set what you feel to be an appropriate sentence in this case. As I think about this, it reminds me back, we always go back to jury selection. And if you recall, you were asked a question by Ed, and each of you are on this jury because you were asked individually, tell me if you were me, why I would want you on this jury, okay? Fair enough question. You all addressed it. You're all very open. And the reason that each of you is here is because you were the ones who told us that I would be good on your jury because I'll be fair and I'll consider all of the evidence in the case before I make a decision. And that's really all I'm going to ask you to do, is to consider all of the evidence. And I don't anticipate you'll hear States 108 again. You saw it. You know what happened. You rendered a verdict that says he acted recklessly. But again, what I want you to do now, or I'm asking you to do, is when you go back to deliberate, I want you to take, like they're going to ask you, take everything into consideration, okay? You've already told Tony that what he did was wrong. You know what happened. You know why it happened. You know how fast it happened. That's not in dispute anymore. You've decided that, okay? And, it was nice that Wendy was able to tell us about Arlene because it was, and I can't tell you like what I was thinking, but I'm assuming, from my years of experience, and I watch expressions on faces, you found it moving, and it gave her an opportunity to tell us about her little girl. Okay, so, I mean, that's some moving stuff. And then here comes the hard part, you know. We're the other side, okay? A lot of people think of us as the bad guys. When we ask that question on the questionnaire, what do you think about prosecutors, and then what do you think about defense attorneys? You know, the thing about defense attorneys in criminal cases is people usually don't like us. They usually hate us until they need us, you know, or one of their family members need us. So here's the hard part. We have to ask you to view him as a human being too, okay? All right? Because, you know, he wasn't living in your community, or a community like yours. And I know from the questionnaires and stuff that he's not educated like all of you. He didn't even get through high school, he told you. And he told you he carries a gun because of the neighborhood he lives in. And let me touch on that for a second, because, you know, the Second Amendment is really interesting, you know. And Texas is like the Wild West. I mean, you talk to people that you know, they view Texas as the Wild West because, you know, we have open carry. Like, you can carry a gun on your waistband, you can carry a gun in your car, and I'm not going to get into a political dispute about how I feel about it, and I don't know how each of you feel about it, but you'd have to agree on one thing, that when you allow people to just walk into a store and buy a gun with no licensing, no training requirements, nothing to teach them how to respond when they use or feel they have to use the gun, and it kind of encourages self-defense. If you think about it, it's like a recipe for tragedies and disasters like this, because in his case, for example, you sell him, you know, he's been robbed multiple times. You don't know how he's going to react, but maybe there's a way to start having a dialogue about this, okay? And maybe we can do some things, hopefully up in Austin, to prevent these tragedies. This is not on you guys. This verdict is not going to send any message to our lawmakers in Austin to change things. It's just something that I felt I had to say and I had to point out. But getting back to Tony, and I was talking about the fact that Tony is human, okay? He's not perfect, we know that, okay? And, I mean, the state pointed that out and said he's a different guy. I mean, you watched him during the trial, you watched him on the stand. There's one photograph where he was meeting with the police right after the incident occurred, and he's got his head down. You can kind of see what his demeanor is, and they want to talk about he's an angry man. He's a man that will still carry a gun. He's a man that would point a gun at his stepson. You know, he's also a man who doesn't even have a high school diploma, who goes to work and picks up trash in the parking lot. He restocks ice and he restocks beer to make some money to survive, okay? He calls and checks on his disabled father every day. On holidays, he does a toy drive for kids in his neighborhood. So what I want, or what I'm going to ask, is that at least one of you, two of you, three of you, someone, when you go back to deliberate, get the jurors, your fellow jurors, to talk about him as a person too. I want to talk to you about knowledge because Mr. Catani made a pretty big deal about pulling a gun on your stepson. You know, it's interesting, we didn't hear from him, okay? But I want to say a couple things. If you really, you know, the other, besides sympathy, anger, revenge, the other thing that you guys are allowed to consider is your logic. So let's talk about logic. Let's talk about that incident back on I guess it was March 29th of 23. Tony's sitting at the truck where he works, and you know, knowledge comes up, and you know from the evidence, we were allowed to put it in, that knowledge told us when he walked up and they had words. Now, mind you, Tony didn't go looking for knowledge. Knowledge walked up to Tony. He came to Tony, and knowledge told us, and that's evidence in the case, that he was going to pull out his mace and mace Tony in the face, okay? Tony didn't shoot knowledge. Tony, in his defense, pulled out his gun, pointed down towards the barbershop and said, you need to go on back down there. Now, how threatening was that to knowledge? Well, on the video, you see they both walked in afterwards, okay? So, you know, how could he claim that he was offended or it scared him? Tony put the gun away, he walked in the store, knowledge walks in after him. But the next day, so if that doesn't tell you it wasn't a big issue for him, the very next day, Tony's working at the store. He's in the store. Now, I don't know about any of you, but I would think that probably if somebody actually pointed a gun at you and you found it threatening, you probably wouldn't go to their workplace the next day and walk in there. But he did. And he actually had a gun that day, okay? And they had the altercation. On the video, we don't know what words they're exchanging, but we know that he's telling him, Knowledge is mad because he's calling Knowledge's mother and saying he's hanging out or doing some bad stuff that's going to result in him getting killed. And Knowledge doesn't like Tony calling his mother and telling him that. So he goes back down to the store the next day, and what does he do? He walks in. And look, if you're afraid of the guy, if he poses a threat to you, you don't go to his place of employment. I don't care how many times you go there a day, at least the very next day. You might let things cool down, but he doesn't. He walks in there and he's got a gun, and he throws the first punch, and they're making a big deal about it. But on the video, you know, you can't throw the first punch, get your ass kicked, and then complain about it. That's kind of like whining, okay? You know, man up if you're going to start something. But they don't have a lot to throw at you about his past, because like he told you, he has no criminal history, okay? 45 years old. He's not a guy here with a laundry list of crimes he's committed, okay? He's here because I don't even know how to describe how that robbery and the timing of the family, Mr. Alvarez's truck pulling up and being in the middle of it there's no reasonable explanation for any of that. That's like fate. And, you know, let me just say this. I don't know if it's even come out, but how about Armando? They're right. He's got a right to take his family out to dinner. And the poor guy, he's driving down the street, okay? And all of a sudden he finds himself in the middle of a robbery, okay? And he thinks they're shooting at one another. He's got to make some really quick decisions, okay? He's got to decide what he's got to do. Do I throw the car in reverse? Do I try to go to the right? Do I go to the left? I mean, he's just doing it, okay? He's in survival mode for his family, okay? And the timing of that is just crazy. I don't think you'll ever hear of something like that happening again in your lifetime, okay? The critical timing, I don't even know what to say about it, but what you told Tony was, by your verdict, that, you know, there's definitions about reasonableness, like, you knew the danger existed and you totally disregarded it, Tony, okay? Really, he shouldn't have shot, for sure. Clearly, he didn't know that there was a family in the truck, and we know that him mistakenly believing, I don't care what the reason, the timing, the sounds, what caused it, the way he approached it and what he did was wrong, okay? And so we talk about sentencing people, okay? And you're supposed to consider, like on the questionnaire we asked you about punishment, deterrence, and rehabilitation. We asked you, what do you think is the most important, okay? And you guys all answered it. And here's the thing, it's a combination of everything, okay? You know, obviously, since he touched on probation so much, you know, a person can't have a gun on probation. And they can be visited at their place of employment. They can be visited at their house, but that's not really the point. I think that you take into consideration deterrence. You take into consideration what's punishment. You take into consideration rehabilitation programs. You know, it's a collective thing, guys, okay? That's really all it is. So, in closing, I just want to say this to you. Don't rush to judgment, please. Consider everything, consider both sides, because no one wins in this situation. You got two families that are suffering from what happened. You know, I get it. I get it. But please don't let anger and revenge cloud your thinking about really what, you know, how do we handle this situation? Let's think through it and give consideration to the fact that, you know, he really is only human. And again, he's not perfect, okay? But he's a person who started out as a victim and within seconds became a defendant. And I mean, make no bones, I'm not saying to you that conduct doesn't have consequences, and that you could go back and say, well, he's the one who decided to shoot at the gun, to shoot at the truck. But take into consideration that, I mean, this is not just a drive-by shooting where for kicks he shoots at cars, okay? I mean, if he doesn't get robbed at gunpoint, I'm sure you all agree he doesn't just shoot at a passing by truck or vehicle, okay? So that's really all I'm asking, okay, is to consider everything, consider both sides, and then you guys have been good. You've listened to us for days now, and this is emotional, and I have to say I don't envy you sitting in those chairs. I really don't. And I hope that after today, there's some way that you can unwind tomorrow, because I know I'm going to. And I just want to thank you personally for your time and your attention. Okay, guys? Appreciate it.
Thank you, Mr. Sosa.
Thank you.
You want to go? You have 19 minutes now.
Thank you. We do appreciate you sticking on for 8 days. I know it's been a very long and emotional 2 weeks. I think the way it was timed yesterday with listening to Wendy talk about how their night started, and then listening to Tony right after that talking about how their night started. And it was just two families talking about their Valentine's Day. and how 2 families were destroyed within a matter of seconds. Because make no mistake, 2 families were destroyed by one robber. One robber's actions. Because like Mr. also said, had Mr. Earls not been robbed, none of this would have happened. He's not a monster. He isn't. He's 45 years old. You don't make it to 45 years old with no felonies if you're a monster. He made a mistake. He was trying to protect his family. He reacted in a matter of seconds. He had seconds to think about what to do, just like Armando did. Was that the right call? No, and he told you that. He told you that from the stand. He said he has thought about that night every single night for the past 3.5 years. He has thought about Arlene every single night for the past 3.5 years. There's not a night that goes by that he does not think about her. He's a father of 6 girls. He thinks about that little girl every night. He's not a cold-blooded killer. He isn't. That's not who he is. Cold-blooded killer would not be sitting there sobbing. That's not who he is. He is somebody worthy of redemption. That's the kind of person we should want back out in our community. Somebody who cares about kids. They told you he does a toy drive. They told you he does help kids out there. He has 6 girls he cares about that depend on their father. He's so worried about them with the cameras, with all these people here, that he didn't want to say their names. He doesn't know what will happen. He's terrified for them. Because he doesn't want everybody to think he's this cold-blooded killer. He isn't. That's not who Tony is. We want you to listen to all that and take all of that into consideration. We're not asking you to forget about Arlene when you go back there either. We understand there's a 9-year-old. We understand that. We know that. We're just asking you to listen to all that. Take all of that into consideration. This is not a 20-year case. That man has been sitting in jail for over a year. Thinking about that little girl every single night. We're just asking you to consider all of the facts. Probation is one of the considerations we are asking you for. You told us during jury selection that that is something you would be willing to consider. Make no mistake, we understand it is a tragedy. We understand that there is a dead little girl named Arlene. We understand that. We are not forgetting about her, but there are 2 families who were destroyed that night. Not just 1, 2. And it was a result of somebody else's crime, the robber. And had that not happened, we wouldn't be sitting here. He wasn't out there just shooting at random cars. He carried a gun for protection, to protect himself, to protect his family. We're just asking you to please consider everything. Consider who he is. Before you make your decision, please consider who Tony Earls is.
State, you have 28 minutes. Remember, you have to stay on your side.
Thank you.
Thank you.
We're still talking about the robber, as if it's the robber's fault. Make no mistake of it, if he was just shooting at random cars, it would be a felony murder and you'd be facing 5 to life in prison. The reason why the robbery and the reckless conduct is why it's 2 to 20. But you remember during jury selection, we talked to you all about a lot of things. And one of the things we talked about is, if this was your world, you know, what do you think the most important thing in assessing the appropriate punishment? Remember that? And on your questionnaires, you had a choice between punishment, rehabilitation, and determinant, or deterrence. 10 of y'all put punishment as number 1. 1 of y'all put deterrence as number 1, which is, y'all explained to me, trying to prevent crime, sending a message, what we would hold accountable, and 1 of y'all put rehabilitation. And that's okay, because you also had combinations of it, right? Second and all that. You also said you would consider the full range of punishment, depending on the facts. And I was the first one to kind of talk about it. I was like, what the law says is you have to wait to hear the facts to then assess the right punishment. And as soon as you start hearing the facts, you may decide, oh, well, this isn't going to be a probation case. And as soon as you start hearing the facts, you may decide, okay, this is going to be a 20-year case, right? And I gave a hypothetical when some folks said, wait, for killing somebody, you consider a probation? I gave a hypothetical of shooting in the air, like Maroon was saying, bullet coming down. And it certainly wasn't putting 7 bullets into the side of the car. So the biggest question was, legally, was could you consider 20 years in an appropriate case? Remember that? That was the legal thing. And you all said you could. So when you learned that the victim in this case was a 9-year-old child, you knew it was an appropriate case. When you learned the defendant just didn't shoot in the air, but 7 times into a car, you knew it was an appropriate case. And then in the punishment phase of the trial, when you learned 13 months later, he's still carrying a firearm, still being reckless in it, and pointing it in the direction of a family member, you all knew it was an appropriate case. 20 years is appropriate for our community, for this defendant, and for Arlene. This is not the rehabilitation part of the trial. This is the punishment part of the trial. In a lot of ways, this part of the trial is really about us and what we say is acceptable. I already know the folks on here who believe in the right to bear arms and the people who believe in guns are probably the most offended at the defendant's conduct. You have an opportunity to send a message to the community that if you have guns, you have to be responsible. With all due respect to Mr. Oso, I don't agree. This is not legislation to be changed in Austin. This is stopping people like this defendant. Maybe the law should be changed to say if you recklessly kill a child, you should have a punishment range of 5 to life. Some of y'all might be thinking that because 20 years is not appropriate for Arlene. Maybe that's the legislation we need to talk about. It's not guns. This isn't a gun issue. This is a person issue, and how a person deals with guns. That's what this is. And it's not revenge. It's justice. It's what's appropriate. So let's talk about the defendant. You knew when you learned in the punishment stage of the trial, when you saw that video of him carrying the gun in a public place and pointing it at his stepson, you then understood what had happened 13 months before a little bit easier, didn't you? Some of you are probably thinking, John, that would have been nice to know in the guilt phase. If I had known about that, maybe my decision would have come back in 10 minutes instead of 45. But the law protects them. And we talked about this during jury selection. You're only going to learn about the facts of the case, not the other acts. Well, now you know how confident we were when we said he got out of that car angry. Because that's who he is when he has a gun in his hand. He sits here meek, he purposely cries in court, but when he's got a gun in his hand, he's a completely different person. And he's a dangerous person. So now you know when he got out of that vehicle and decided that a human life was worth a wallet, 20 credit cards, and $20, now you understand why. If he believes a human life is worth a wallet, 20 credit cards, and $20, how in the world can we not believe a 9-year-old child being killed is worth 20 years? If you do that balancing and that logic, there's no other solution. But then, some of y'all I know are trying to give the defendant the benefit of the doubt. Some of y'all in the first phase of the trial might have been saying to yourself, gosh, maybe this was just split second, maybe this should never have happened, and then you learn about the aggravated assault, and you're like, oh, now I understand. But then some of y'all might still have been kind-hearted enough, wanting to believe in rehabilitation, that you're like, when he takes a stand, give me something. Please, give me something. Other than just saying, I cry every night. Of course he does. He's a human being that he killed a 9-year-old, but he has taken no responsibility. He won't even acknowledge what I did shooting that vehicle was wrong. You saw it on the stand. I gave him every opportunity. You saw him.
That's a mischaracterization. He took responsibility.
So, remember my admonishment? That's their opinions, both sides. Everything comes from witness stand. You guys make the determination whether you took responsibility or not. Okay? You may continue, sir.
How many times did I ask him, you agree with me that shooting into a truck where you can't see in is a reckless act? And he actually said, I can't say that. And then with the aggravated assault becomes, I was pointing down the street. And you're hearing the same things in that call to the officer. I had to do it. My life was in danger. No, you know now what he did on Valentine's night was not anything he had to do. It was something he wanted to do. And the result was the death of a 9-year-old child. So those of you who are hoping to hear something different on the stand, hoping to believe in human dignity and sorrow, I'm sure you were disappointed. Because you can't say in open court, I'm sorry, and not say, I could have done these things different. Or not get the penance that you deserve. It was a hollow So in some ways, this defendant has given you no other choice but 20 years. Folks, if killing a 9-year-old girl does not stop you from reckless behavior with a gun, if killing a 9-year-old girl doesn't change your ways, then nothing will. We're just fortunate that he commits his crimes on surveillance. And you get to see on television. And he, on that stand, is watching what you're watching and still denying it.
Objection, that's a complete mischaracterization of the
That'll be
evidence.
sustained.
Y'all will
Disregard that last statement.
Judge asked for mistrial.
That'll be denied, sir. You may continue, sir.
Y'all will remember.
You have 18 minutes left, by the way.
So he himself deserves 20 years. But this is not just about him. It's about so much more. He just didn't kill a 9-year-old child. He killed Arlene. And yesterday, through her mom, she came to the schoolroom. And for the first time, we got to know who she was. With her big personality, you could see as she's 9, starting to play with makeup and nails, wanting to be like her mom, a successful hairdresser. You can hear her say, "Don't come in my mom's salon," saying her hair is orange and yellow. Remember that? Or on that Valentine's Day, when Armando comes home, she said, "I told you, Mom, he wasn't going to get you anything." Came in here and she talked to us. And then when Wendy told us Armando felt awful, and he's like, "Oh, okay, let's go out to eat." You're reminded of Armando's testimony when he said, "I realized that it was a mistake to choose work over family." How many of us probably related to that? She entered this courtroom and it reminded us it's just not a name, it's just not a 9-year-old girl, because when you kill a child, and he did, you kill everything they will become. She will never have her 15. She will never fall in love for the first time. She will never have her first kiss. Armando will never be able to walk her down the aisle. She will never have the career she aspired to have. She will forever, for the Alvarez's family, be at the age of 9. Wouldn't they love if she could get 20 years? Wouldn't the Alvarez's love for her to be back with us when she's 29 and have her whole life in front of her? How in the world could we give him any less than 20 years? Because if you give him 20 years, she will still be dead. She will still be 9. She will still be a memory in all of their hearts, and I know in y'all's. There's a reason why we didn't show that video of Armando taking her out of the car again, because it will forever be in your mind. I am sure y'all have thought about that moment when you went home. You will forever do it. The only thing you can do, is to make this right. It won't bring her back, but it will tell this family, this jury, our community did all they could do. That's all we're asking. And it won't bring her back. But maybe it will be a part of the process that they can then heal. He had an opportunity after he did that 4th, 5th, 6th, 7th, 8th, 9th, 10th shot, when he found out that he killed a 9-year-old, he had that opportunity and he didn't take it. Don't reward him. That's not fair. That's not just. And she's still gone. Our community deserves for him to get the most. And make no mistake of it, I'm not cavalier. As a prosecutor standing up here asking you to give the maximum sentence, I'm not doing it in a cavalier fashion. Because not every case deserves maximum punishment. But this one does. There is a reason why we picked you. Y'all are from all over our community. Y'all are as diverse as we can get. We have people that are in their early 20s, and we have people 70. We have people who are just beginning their lives, and those of us are looking back at our kids, grandkids. We have pro-gun and okay with guns and against guns. And there's a reason for that. Because we knew we would be standing here right now. And when you ask a jury to give the maximum penalty, it has to come from all of our community. So what we're going to ask you to do is, in the same fashion you came back and found him guilty, to come back and tell Mondo and Wendy and all of us that we will do what the law allows. Some of y'all might be thinking it should be more. And if y'all agree, then go ahead and put a $10,000 fine on there. But this isn't about money, this is about people. And justice demands, you know, justice demands. It won't bring her back, but it will at least say, we've been stricken and we did all we can do. We now give it to you to speak for our community. And what an honorable thing that is.
You've all heard the punishment argument by defense counsel. I've read you the law in this case with respect to punishment. Please now go with Deputy Sam to the jury room and continue or start your deliberations when it's appropriate. We'll stand in recess until a verdict is reached.
All rise for the jury.
You all may be seated. We'll stand in recess.